Intellectual property. Bear with me on this one, it's a long one. So I'm just going to go through each of the categories of intellectual property as I understand them. They're trademark, patent, copyright, and then we get into copyright limitations, licenses, trade secrets, and intellectual property attacks. So with trademark, basically that's associated with marketing a product. So a logo, a symbol, an image. Nike the swoosh, McDonald's the golden arches. You can figure that one out. There are two kinds of symbols associated with a trademark. There's the little TM thing that you see, and it means it's an unregistered trademark. And if you see the little R in the circle, that means it's been registered with the U.S. Patent and Trademark Office. Um, there's something called a service mark, and it's got a little SM symbol. And I'm a little hazy on this one, or actually I'm a lot hazy on how this one is really distinguished from other aspects of trademark. But from what I've read and Googled and even in this book, it's like the slogan of the company in a lot of cases, or it can refer to a product within a company. Like this is a very bad example, but like the name of like Chase Checking, um, or I think I read an example somewhere that said the NBC sound, that doom 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 sound, is also something that would be considered a service mark of NBC. A patent offers the owner the ability to sell, manufacture, and distribute an invention. So the patent has to be novel and unique. So you can't just go and patent something that's already been invented. And the patent lengths vary around the world, and by the type of invention they are. But generally, they're 20 years from the initial filing, and after that, the invention goes public. Copyright, it's typically associated with artistic, musical, or literary works, um, and they're really key or specific about the fact that it's the form of expression that's being protected, not the subject matter or ideas. So I suppose if you had an idea about who framed Roger, I don't know, like Bigfoot or something, and it's a theory that's already been uh, put out there by other people. But you write a book and it's your take on some aspect of Bigfoot or the Yeti or the Sasquatch. Uh, then it's the actual book that you write that would be protected, not the idea. Uh, right. That's tricky. So by default, the creator of the work is actually the copyright owner. Um, but you can get a formal copyright, and in the United States, that's at the Copyright Office. I think in the olden days, I don't know if people still do this, but you can drop your idea or your copyright into an envelope and mail it to yourself, and get it postmarked. That was the way that people did that. Um, I suppose you could send an email to yourself with the same, using the same concept. Um, with software, it's treated similar to literary work, but when you're a software developer, if you work for a company, um, you really have to make sure it's clear who owns the actual copyright on the software. Typically, it's going to be the company, but I think it needs to be spelled out because I think there's probably a gray area there. There definitely is. Some copyright limitations are first sale, which means that if you buy something that's copyright protected, like a CD or a book, that you can then take the CD or book and actually sell it to someone else, and that doesn't violate copyright. With fair use, uh, you can use something like a song or a book. You can use portions of it to write like a book review or a music review of an album that comes out. I think this one is a bit tricky. Again, I've done some Googling on this one, and I haven't found really clear cut examples of it other than of book reviews. But that's my understanding of fair use. It's that you can you can use aspects of someone's copywritten material, and as long as it's done. And I read that it's in a lot of cases like a parody would be considered fair use as well. Um, with licenses, that's the contract between the vendor and the end user. Um, Most agreements do not allow you to modify or sell the software that you're using, only to use it. That's pretty straightforward. With trade secrets, it's proprietary information that's essential for a business to compete. So, like Google's algorithm is a famous black box trade secret, um, and something I had did not know and just actually learned today was that. In order for something to be considered a trade secret by law, the company who owns the secret has to apply due care and due diligence towards protecting the secret. So, um, if you're not, if you're being careless about the secret and people gain access to it, and you haven't done your due care and your due diligence, then it's not necessarily considered a trade secret by definition. And the best example of a way that companies use to protect their trade secrets is with NDAs. So that's a non-disclosure agreement. And then lastly, intellectual property attacks. So those include software piracy, corporate espionage, counterfeiting, typo squatting. Those are all examples of intellectual property attacks. And I think I have cyber squatting. So that is the end of intellectual property.